Today we received an update from NAR. We're going to react to a few key points in a video that they just released. The video itself is about 30 minutes in length. Now, we're not going to go through all of it. We're going to go through about 3 to 4 minutes of it. The specific timestamps, I already labeled them here so we can get straight to the point. In summary, the video itself is from the president of NAR and also their chief legal counsel. They go on to address the things that we kind of already know in terms of what the proposed settlement is supposed to cover, what it's going to look like, why they took their stance that they did. So we've talked about that in the past. We're not going to look into those particular points in this video. We're going to go into things that were left unclear. They do provide some clarity on several things that were either omitted, weren't thought about previously, or were thought about but didn't have time to react to actually communicate with the rest of the agents on what that would mean. So you're going to see what that means here shortly. We're going to get into the timeline first in this particular video. Again, this will be linked down below for you to check out. We're just going to be looking at some important key items that they actually presented in this particular breakdown. So let me get to the timestamp. Actually, I already have this timestamp. What you're about to see is the timeline. So we have an appropriate expectation on this proposed settlement, when certain MLSs, certain brokerages need to file for, well, you'll see. Check this out.
Yes, absolutely. Thank you, Kevin. First, note that some of the dates on this timeline, on this slide, are still tentative. As you know, on March 15th, the settlement agreement was signed. On March 22nd, we expect the plaintiffs to file a notice of settlement. Meanwhile, NAR will proceed to withdraw our pending motions and request a stay in the litigation. By the end of March or early April, we anticipate the filing of a motion for preliminary approval. During the 60 days following that motion for preliminary approval, it's imperative that all realtor MLSs execute Appendix B, as I mentioned previously. Brokerages above $2 billion in total residential sales volume and non-realtor MLSs will also want to adhere to the timeline set forth in their respective appendices in order to be classified as released parties in the settlement if they so choose. All
right, so let me paint a little bit of color beyond that. So the important date is going to be the motion for preliminary approval. Once that happens, they have those 60 days, that they being the associations that were not automatically included, the brokerages that they have the option of continuing to settle outside of the settlement. So whenever NAR did this settlement and did the $418 million settlement, there are certain brokerages above $2 billion in sales brokerages, the entities themselves that they could not cover. Now, the agents themselves, over 1 million agents, they were covered. They were covered in the release of liability. That was the reason for the settlement, release of liability. So while the agents themselves are released from this whole thing, if you will, if this goes through, the entities themselves, like Compass just settled on Friday. So EXP, Realty, Real Brokerage, Howard Hanna, any major brokerage that you've heard of that has not cut their check yet, they will be cutting their check. So they have an option of either going and settling outside of this settlement and or using the formula that was detailed in the proposed avenue for settlement here. So essentially they provided a mechanism for those brokerages to settle to the tune of, if you're doing $2 billion in sales, you're looking at a $5 million proposed settlement to be included here, to buy your way out, if you will, to be included in the settlement, to be released alongside the NAR, what the NAR ended up solving for or negotiating in. I don't suspect a lot of brokerages, just to be upfront with you, I don't suspect a lot of brokerages to try to be included in that. I think that they're going to venture their own path and write an independent check out of that. So the only brokerage that has settled, only major brokerage that has settled after the NAR settlement, knowing full well the options that they now had, was Compass, and they decided to settle outside of the vehicle that NAR allowed for the settlement. So Compass settled for $59.5 billion. Now, had they tried to use the math or the formula that NAR had laid out, they would have been paying substantially more. So I don't blame them. That's why I believe that brokerages are going to not really go into this, look into this 60 days after the fact, this preliminary approval, once it gets going, the 60-day timeline. I don't think they care, because I don't believe that they're going to actually try to be included and be released in this particular settlement. I think they're going to venture their own path. I would be shocked if any major brokerage that's included or that is cutting their checks in the future actually goes through with this potential vehicle that they've carved out.
Early April, we expect preliminary approval on the motion. Then, as we approach mid to late July, we will implement the practice changes that are part of the settlement. By the end of July, we expect class notice to be disseminated. In September, we anticipate the filing of a motion in support of final approval. Then finally, looking towards the end of the year, we estimate the final approval hearing will occur in December, which will mark the culmination of the settlement process and hopefully a approval of the final settlement. Kevin, back to you.
All right, so that was a timeline. I think it was important to understand and provide a bit more clarity on what the rest of the year can look like. Is this going to change what we were looking to do in terms of implementing the changes that have already been proposed and laid out? No, nothing changes from that regard, at least if this timeline stays clean. It was just presented. Of course, things are subject to change. There's not an expectation of the plaintiffs pushing back in, having anything to say in this regard in terms of right now, what we're just looking to do is getting the court's approval. So let's go to another timestamp here, which talks about loan limits. This was a question that was proposed to me quite a bit, not just from you in the comment section, but also from my own real estate agents that were a little bit unclear on the loan limit. So as we know, whenever you're seeking compensation now, you could present an offer. You can present your compensation per se in the offer that gets submitted. So the question was about, well, how is the interested party contribute? How does that factor into interested party contributions? And they go on to answer it right here. So I'm glad that they provided feedback on that.
First, what are interested party contributions?
Yeah, interested party contributions. There's something that we deal with regards to Fannie and Freddie Mac and FHA. They specify limits on how much a seller or broker can contribute to the buyer to pay for services typically paid for by the buyer. These payments are called interested party contributions, IPCs. So is compensation paid by a seller or listing broker to a buyer broker considered an IPC? The answer is no. The agencies exclude fees that are traditionally or customarily paid by the seller from IPCs.
What about VA loan?
All right, so just to put a bow on that one, in one of the questions that had come up, in the past, and I had it myself, was, all right, so whenever an offer is presented that is asking for a concession from the seller to the buyer in order to compensate the buyer's agent, would that count towards the IPC? So would that count towards something that would go towards the loan limits from a lender? So from a lender, if you wanted to, let's just say you wanted to concede some commission as an example, you as a buyer's agent, well, there are certain limits that prevent you from going, and not that you would, but rebating or conceding all of your commission, assuming that it doesn't hit a certain threshold. So whether it's a 3%, 4%, 5%, whatever the limits happen to be, I don't remember exactly, but that's what they were talking about. So you can imagine that if a offer gets presented, a buyer is asking for certain concessions from the seller, and they themselves are getting compensation or getting some rebates in terms of to be able to qualify for the loan. Well, now they're asking for additional concessions to cover the buyer's agents when they typically didn't have to do that. So there'd be some restrictions on how much. Long story short, whenever you're presenting an offer and you're asking for seller concessions to cover the buyer's agent's commission, that doesn't count towards those limits. Those loan limits wouldn't be impacted. Now, the other question that came up was VA buyers. Now, you're not going to like this answer, or maybe you will, but it's not a defined answer. I'll kind of go ahead and give away the ending with the VA question.
And the prohibition on buyers paying commissions directly.
Yeah, this is a question that we've gotten a lot, and obviously it's a concern for us. The VA has not addressed whether it will change its requirement prohibiting VA buyers from paying the commission. NAR has engaged with the VA on this issue, and we remain committed to working with the VA so that veterans are not left out of the market or forced to consider alternative loan products. So we do have an FAQ on these financing questions available. It's available now on facts.realtor, FACTS.realtor.
So in other words, not sure yet. Not sure yet. So I'm not blaming them on this particular regard. I know there's a lot of things going on. Now, the other point that, well, anyway, so yeah, the VA question is still out there. And I would venture to guess pretty sure that it's going to be resolved very, very soon. Now I understand that the government moves slower than we would venture for our comfort, if you will. But this is something that think about you're having to win the court of public opinion here. So think about this ruling. If it was found out that this impacts VA loans, if it impacts veterans to this degree to where they can't purchase because of this particular ruling, then that would be a huge thing that would have Mr. Michael, the lead attorney that brought on all of this stuff, and it would also include the media coming out in uproar saying that, hey, this is impacting VAs, and anyway, they're going to avoid that at all costs. So I suspect there's going to be an answer. We just don't have an answer today on how that's going to be worked out specifically for VA buyers. At least that's my expectation. Now, something I thought was interesting was just to show how the sausage is made, basically, where one of the things that, as soon as this was released, one of the comments that I made in the video itself was, this probably got leaked because by the time that we found out about it, the actual verdict hadn't been done. And he goes on to confirm this. Now, the only reason that I'm including this particular segment is, again, to show how the sausage is made, because sometimes, let me backtrack. It was a bit shocking for a lot of agents. The agents that when we have our masterminds, they bring this up, and also in community groups that I've seen, it was a bit shocking on how dishonest the media was representing what was actually happening, right? So what was actually being shown out to the public. So much so that you even have the president commenting on, realtors do the right thing and all this other stuff, regardless of your political affiliation. A lot of agents saw how it was being portrayed out in the media. And I think that what he's about to share right now is, I think it's good to see, because a lot of us that may not be as in tune with, let's just say, politics, or as in tune with the way that media represents itself or whatever, I think we were just blindsided with just all of this press just in full sprint mode that you're looking at it. Well, we'll discuss it after he shares a little bit of inside baseball here, which I thought was very, very telling. Doesn't surprise me, but I thought was super telling that a lot of agents need to hear.
I think that it's important to share a little more information about our path forward. So upon settling and signing the settlement agreement, our strategy was to reach as many NAR stakeholders as possible on the day of announcement. We had a robust plan to follow-up meetings, and we're going to have follow-up meetings in the days and weeks ahead. With the settlement agreement, both parties agreed to maintain strict confidentiality until 10 a.m. Eastern on March 15th. However, it's clear that the agreement was leaked to the New York Times early, despite that confidentiality obligation. Upon learning of the breach, NAR immediately activated its planned cascade of communication on Friday, March 15th, across multiple stakeholders.
So I hope you caught that there. there was a planned NDA, so from both parties. So it was executed, it was signed. That means there's two parties: the plaintiffs and the defendants. The defendants is the NAR, and in this case, yeah, NAR, and the plaintiff side, so the attorneys and everyone else on that side. So there was an NDA in place until 10 a.m. Eastern time on Friday, so March 15th, when this was announced. Well, the New York Times article was published 30 minutes before. Well, you don't just write an article like that in a couple of seconds, right? So if you look at the timing, so there was supposed to be nothing public, if you will, until 10 a.m. Central. Well, someone had the story so far in advance that they were able to write a 2,000, 3,000 word article. I don't know how long that article was, but it was fairly lengthy, to where they could even beat the deadline by 30 minutes, right? So, and I know for some of you that might be more interested or have a bit more experience with media, you're going to say, well, Jaime, that's normal. That happens a lot. There's always these leaks. But I think for a lot of folks that you're working in your profession, especially you here, you're mostly real estate agents that are watching, you're not used to seeing all of this type of shenanigans, because you're going out showing homes, you're writing out offers, doing everything like that. And to see how it actually happened in real time, and then within a matter of minutes, all of the mainstream media, I know it sounds weird saying mainstream media, I recognize that, but all of the media, let's just say media out there, all in, when we've done several videos reacting to what they've been saying, but all in lockstep, saying the exact same thing and villainizing you in the eyes of your past clients, to where they're now seeing, hey, I sold a house with X, Y, and Z, or hey, I bought a house with X, Y, and Z. Did they cheat me? Did they? And that's when they're firing off questions, asking you questions about that, right? So it was a bit disingenuous, significantly disingenuous. Now, again, a lot of folks are going to say, well, that's another day that ends with Y. I recognize that. But I thought this was very interesting. I'm glad that he brought this out, because NAR, love them or hate them, they're in a losing proposition from day one, regardless of what happens. But one of the big critiques has been, why aren't you out in front of this? Why did you not let people know and all this other stuff? Regardless of what ended up happening, well, if somebody has a jump start and can get and weaponize hundreds of TV stations, hundreds of articles, and you have just one party here just trying to catch up to the media, that's just an impossible task. So I'm glad that he brought this up, because it's something that in that video that I made right immediately after that, the announcement, I did mention that. So I'm glad that he brought this up, because I think it's important that we know that. Anyway, this is the latest from the settlement. Let me know if you have any questions down below, but also let me know what you think the next steps actually are going to be. And also, we have the ongoing quiz, or the ongoing game show going, where who's the next brokerage that's going to sign the big check? Who is going to settle next? So we've had Anywhere was the first one, then it was Remax, then it was KW, then it was NAR, and then it was Compass just this past week. So who's going to be this week? Who's going to be next? Let me know in the comment section down below. I'll see you on the next one.